Hello, welcome again to the Law Professor. In today's discussion, we want to take the discussion regarding examinations further. And we have here with us once again Dr. Karibi-Whyte. She will be taking us through the subject of jurisprudence and legal theory, talking about the expectations of examiners with respect to answering questions. Dr. Karibi-Whyte, you are welcome once again to the channel. And what do you have for us with regards to jurisprudence and legal theory?
Okay, thank you for having me. I know that jurisprudence is always a bore to many students. I know that many students, if given the opportunity, will not offer jurisprudence and legal theory. But unfortunately for us in Nigeria, they just have to offer it. Now, let me start with saying there's a difference between jurisprudence and legal theory. I think that's the starting point. Jurisprudence it's about thought. It's about thinking. It's about a bit of logic, about words, concepts. That's jurisprudence. But legal theory is about application of certain concepts to lived experience. So when we're talking about jurisprudence, take for example when we talk about person. If we want to analyze who a person is in jurisprudence, we will not be talking about heights, feet. No. We will be looking at that word person. We will be construing it and deconstruing it about that word person, or property. But when we talk about legal theory, we'll be concentrating on lived experience. And what do I mean by lived experience? As students of law, you have certain rights and privileges in the university. What are they? And what are the theory behind your rights in the university? For example, the Nigerian state has a theory behind it, and that is the theory of social contract. That's the theory behind it. So we need to get from the first instance the difference between jurisprudence and legal theory. Having said that, let me take a particular question and see how we're likely going to answer it. It says, jurisprudence approaches law from a high level of abstraction, unlike legal theory, which focuses on practical problems of order and regularity. To what extent do you agree with this proposition? So, what does the examiner want? The examiner just wants you to tell us about jurisprudence and legal theory, the difference between jurisprudence and legal theory, and give examples. If you're going to talk about jurisprudence, the abstraction, the thought pattern, the thought process, then when you get to legal theory, you give us examples like natural law. When we say section 33 subsection 1 of the Nigerian Constitution talks about right to life, where did we get that one from? Because it's from the natural law theory. So you'll be giving us such examples. When we talk about equality of persons, where did we get that one from? We still got it from natural law theory. You give examples of whether it is Aquinas that said it or St. Augustine that said that. So those are the way, because in legal theory you will always have examples, lived examples that we can relate. But in jurisprudence you may not really have a lived examples, just thought process, just thinking, just construction of words. Now, another question which is very germane to us as law students says the lawyer's business is with words. They are raw material of his craft. This is because words are not only tools of thought but also control it. People tend to think in terms of their language structure. This is Dyers. Now, critically discuss the contributions of jurisprudence to the lawyer's craft. what does the examiner expect you to say? First and foremost, the only thing that lawyers do well and should do well is the gap of talking. A lawyer that cannot talk will have I don't know what to say, because how do you persuade a judge in a law court if you cannot talk? So what the question is saying that your study of jurisprudence prepares you for how to communicate. That's what the question is on. So you first tell us what jurisprudence is all about, what lawyers do, and how jurisprudence contributes to the lawyer's craft. That's all the answer is saying. Then the other question, which is always a question that comes up all the time, is Ophelian juror postulations. I also know that many students don't like that Ophelian juror postulations. They don't like it, and if given an opportunity, they will not answer it. But you need the Ophelian juror postulations. Why? Because he tells you about the concept of rights. Right as in wrong, right as in entitlement. If you don't know the juror postulations, when you get to the field and we're talking about fundamental human rights, you may not be able to flow, because a good grasp of Ophelian postulation will make you understand why there is right to privacy, and if anybody wants to impugn on the rights to privacy, the arguments that can be marshaled, to impugn on the rights to privacy. So by and large, what a student of jurisprudence and legal theory needs is to master the concepts, and to know the different jurists talk about those concepts, and to be able to argue for and against.
Thank you very much, Dr. Karibi-Whyte, for that exhibition on jurisprudence and legal theory. Students, you've heard it from her. For you to be successful in this examination, you need to master the difference between jurisprudence and legal theory. You need to understand your concepts. You need to be a master of the words. When we were talking about as she was talking about jurisprudence, and I recall the discussion on legal methods too, the memory of your study of literature came to my mind. In literature, they will tell you who said it to whom, on what occasion, to what purpose. These are the things that are now being tested, indirectly in law exams. So that when you have essay questions, you need to really be using those tools to analyze those essay questions. And you can see from the analysis that they are not actually difficult. It's a question of, like that question said, mastering your words, mastering your English, and using your legal mind to read the question, and you'll be good to go. So we see you at the next presentation on exam series at the Law Professor. Thank you, and best of luck in your exams.